So we're going to start out with just a few general questions. I thought I would open it up first to the audience to see if any of you have any reactions or any questions based on Judge Frank's remarks.
I appreciate all the legal help that's happening. I have a stepson with a developmental disability. One of the questions I would ask is that as the legislation is being passed that is being now looked at by lawyers and judges, that is mandating services, mandating access, mandating integration, mandating self-directed employment and interests, all of those come with a price tag. And the problem I see is that from a legal standpoint, you can rule in favor of requiring these kinds of services. But what is the legal status of providing now holding accountable the funders to actually fund it?
I'm Greg Brooker from the U.S. Attorney's Office / Department of Justice. The only response I have is usually in negotiating what are called consent decrees or settlement agreements, those funding monetary issues are, of course, always the hardest, right? And consent decrees can go on for 3, 4, 5 years. Typically, that's about as far out as we can go. And we try to enforce, right, the provisions in there. But we try to have discussions up front during the negotiations about how is the money going to get moved around? How are you going to, we certainly can't order the Minnesota legislature to appropriate specific line items in their budget. There's all kinds of federalism issues that come into play with that. We ourselves can't control Congress and what they do. So when we're usually dealing with state and local governments, it could be the county board or the city council. And so we have to have those discussions, and maybe some votes have to take place. But things can unravel, and it's a very difficult issue. But we try to package it as best we can into an agreement or consent decree, and we may have to go back to the judge in year 2 or 3 of a 5-year consent decree and say, okay, now there's inadequate funding issues, and we're going to have to reopen this compliance issue right now because let's say an election happened and the funding didn't come through as planned. So very good question. You try to tackle it as best you can while you still have the defendant city, the defendant county, the defendant state, if it's Title II government defendant, still under the jurisdiction of the court.
I want to say a couple things from a slightly historical and sort of larger perspective, and like the judge, because I work with and for Judge Frank, this is not intended to say anything about any pending case that I'm involved in or the judge is involved in, of course. But there are now relatively few people in large institutions. Many institutions have been closed, large congregate institutions for people with developmental disabilities. Why were they closed? Number one, because thinking changed, and a lot of folks realized that they weren't doing as much good as it maybe originally been dreamt. But the cost went up to more than $250,000 a day for these large institutions. And the cost is one of the reasons why they gradually have been fading away. In the early days of the litigation about institutions, just to give one quick example, the Bryce Institution in Alabama, part of the Alabama Wyatt case, the budget for food for the people who live there was 55 cents a day. To give you an idea of what kind of services and funding there were. So that's one piece of it. The second piece is that when you provide the same thing in a large sort of program for folks, the people who need less funding to get good services or supports get mixed in terms of the budget with the people who need a lot. Once you start looking at people individually, it's easier to be more creative and to try to meet people's needs. The third thing, and this maybe goes to a need for legislatures to think about, maybe courts. We have a model in the disability world where funding is not permitted to be an obstacle. The Individuals with Disabilities Education Act, the Right to Education laws passed 1975, the right to special education, so-called, for people with disabilities, does not have an out, a loophole, for school districts to say, this is too expensive. Kids have a right, an absolute right, to the education they need, the individualized, free, appropriate public education. And school districts, unlike some pieces of the ADA, the school districts don't have a right to say, we can't do it. So in terms of advocacy that people might think about, one way to begin to think about the future is, what are those rights that we want to make that will not be limited in the ways and cause the worries that you just suggested some places have created?
Roberta?
The comment I wanted to make, and I want to make the disclaimer, I'm the only non-lawyer on this board.
That means they're going to listen to you there more.
So I'm going to try and put it in what government calls plain and ordinary language. And one of the things that happens is people get stuck in the funding paradigm mode. Well, it'd be nice if we did that, but we need more resources to do it. We need more resources to do it. One of the things that Olmsted says is, perhaps you ought to look at moving some money you're using now that's ineffectively being used in order to meet this goal. So one of my clear messages to the legislature is, it's not always about new money. It's about not funding those things which we know to be wrong or not working or ineffective or inefficient, and redirecting that. But typically what we do is just pile on top.
If I may make one, that I don't hope this won't sound entirely naive, but one thing that comes up in the discussions in light of what everybody has said, and then you can all decide and the public can decide, no matter what the issue is, if that assists in making some of these things happen. And that is oftentimes the message you try to give is, look, we're all spending taxpayers' money, so the feds can't blame the states, the state can't blame the county or the feds, the county can't blame the city. The public has got a growing intolerance for that, because if you have the appropriate priorities, resources should not be the issue. And so hopefully that plays some role in this, because we all have a responsibility, and I'm not that naive not to understand the turf isn't an issue, but that's something that comes up in some of these discussions as well. And I don't know if anybody else has anything on that. But.
My only comment on the funding issue is that I do think there's a role played, sometimes a substantial role played by public opinion, because either before having to go to the full extent of litigation and a consent decree, or even after, in the situation that we are talking about to some extent, where there might be a court order that would require at least an attempt to get substantial amounts of money to comply, if there's public support, including among people who are active in public issues that know the right people to talk to and the right way to get publicity for things, then I think that can be very persuasive to the legislature and the other decision makers who actually will make sure that things happen. And the converse is also true. If there's a lot of opposition to something actually taking place, then that makes it much less appealing for the defendants to comply. And I'm not involved in the sex offender institutional litigation. So using that as an example, I think that's a very easy example where you can see that even if the law might be pretty clear, and again, that's another one of Judge Frank's cases, so we won't spend time talking about the details here, I don't think, but that's a good example where the politics are such that there's very, very little incentive for the legislature or any of the other decision makers to move things forward in a direction that the law might seem quite clear it should be moved. And conversely, I think special education is a very hopeful area because there's so many people who, their families and the individuals with disabilities themselves have grown up now with an expectation of integration, and including both at school and at work, and of inclusion and of choice. And what we're seeing in our office is when people reach transition age, for example, they really are not interested in suddenly going from that kind of a life with those hopes and dreams, to use the judge's terminology, to going to a sheltered workshop, for example. So I think those sorts of longer-term public pressures and also then immediate, more politicized things, like in the sex offender case, can have a real effect.
Okay. Kind of going off of the resources question, I'm really interested in personal care assistance, and I just kind of wanted to gauge what you thought of where wage increases are going to be going for PCA and DSP workers in the future, and whether or not something like the 5% campaign or Best Life Alliance will be revisited in the future.
The best answer to that question is I'm not sure. With every election, not commenting on any election, but with every election, there's a degree of uncertainty as to what the mood of the legislative body will be, whether it's federal, state, local, whatever it is. I think, we all know the sort of common sense logic that we throw out there, like you get what you pay for. You won't have a workforce if you don't pay them viably. I think that this is going to be one of those workforce demand issues. We are so short in a workforce now that even if the government had the money to develop group homes or community living options, they can't get people to work in them. And so it will become a law of supply and demand on one hand. But it's also like we say about childcare. We used to pay some very low rates for childcare, yet that was the most important investment we could ever make, is what we did with our children in terms of helping them grow and develop. So I don't know. I think the 5% campaign has helped. It's raised awareness. It took a few years. But once they do that, then they lean back and say, well, I addressed that in 2000 whatever. I don't have to worry about that for a while, when we all know that wages don't stay stagnant. Well, unless it's a government-funded program, then they stay stagnant. And this whole concept of do more with less has reached us to the point where we can only do less with less. So I'm not sure. Everything this year tells me zero-based budgeting, and not zero-based budgeting, that has a different terminology, but don't ask for increases. Kind of tampons the mood on putting forward what would be the right thing to do.
I have another question along the lines related to funding and responsibility. We have in our state hospital system numerous non-citizens that are living with mental illness and or developmental disability. And they're in the state hospital system and remain there primarily because there's no federal, state, local funding source available. No entity wants to take responsibility for the group of individuals, for community services and healthcare needs. So I'm curious about the panel's thoughts as to the responsibility towards this, giving this population equal access to services, and what your thoughts are as to how to make that happen.
Our office actually has done some work with some individuals, and without getting into the technical ways it can be done, for some people, there are ways that they can get supports in the community and can be unstuck, is the technical term we like to use in our office. So we've done training for the Civil Commitment Defense Panel of Hennepin County, which has a fair number of clients in that situation. And also we've done trainings on that issue for the social workers who staff the Cook Clinic. I'm not sure if you're familiar with that, but they have many of their clients are East African and Asian people who have mental illnesses and also have different types of immigration status issues. So there are a few people, including our office, looking at that issue, but it's fairly complicated. So generally, I would say if anyone here has specific individual case type issues that you think maybe my office could help with, please come and see me afterwards, or my contact information, it should be available somewhere in the materials, I think. So this would be an instance I'd be happy to talk more. But I think I'm reluctant to go into too much detail because the scope of what this panel's supposed to talk about in the next hour is pretty vast. So, but it's a timely issue. And I have to say, without talking about the election, I think any issues having to do with the sort of issue you're discussing are going to be very politicized going forward. And so in terms of what advocacy approaches are more or less effective, I think that's something, as people who are concerned about issues facing people with disabilities, we just all have to keep in mind and be very strategic and careful about how we even frame up certain issues.
I'm going to turn to the panel now and see if you have any comments or questions of one another based on what the judge presented in his keynote.
Yes is the answer.
It's the right answer, David.
And and thinking about my time, I apologize for all these disclaimers. Before I met Judge Frank, before I started working with him, and I've done a lot of these lawsuits, including that Holderman versus Penhurst case, the first case on the right to community services that went up and down to different courts. And I'm thinking about what a lot of you do and may want to do, and I'm thinking about what comes in front of a judge like Judge Frank, or Seamus O'Meara has been a plaintiff's lawyer in this area, as has Pam Hoops. So I want to just mention and then explain my point, if I need to, how that Penhurst case got started, because it's relevant to the work folks here do. And without going into too much detail, when the mom of the named plaintiff, first named plaintiff, found that her daughter was being injured, abused, injuries of unknown origin, broken bones, a whole series of things I won't bother detailing at the moment, she didn't know what to do. And she went to the assistant superintendent and said, "What should I do? My daughter is being hurt here at this place that newspaper at the time called The Shame of Pennsylvania." And he said, "Call David Furliger and sue me," which she did and which I did. And during that case, there were points at which employees of the institution would come to me privately with information that were helpful in the lawsuit. And I have found, as a litigator, not as a court monitor, has nothing to do with this, in this area, the work and the information from employees and staff, officials, policymakers, in all kinds of auspices of care is so important to helping advocates like Pam Hoops here, like Roberta here in Minnesota, helping them do their job. And for those who can't speak up, and I've met folks over decades who can't speak up because you have a job to protect, for example, or other interests that make it difficult, keeping good records, putting things down in charts, in records, in memos, in email, whatever, that will then help when Roberta discovers it with her staff, or when Pam Hoops or Seamus finds that note that is somehow helpful to understanding what's really going on. So we have whatever the title was that was given to this program. It could just as well be, in my opinion, maybe the most important thing I'm trying to communicate today, the role of support staff, professionals in the field, policymakers, agency officials, the role of those folks like you who are or will be in those roles, the role of those folks in the litigation, because it is incredibly important. It's not just the plaintiffs, it's not just the expert witnesses, the lawyers, or the judge. So I want to be sure people here leave feeling empowered to contribute, even in ways that may not be discovered for the next year or two, because the kind of work that a court does when a court analyzes the facts in a case has to come from somewhere, and it's important that the truth be told for the courts to know what to do.
Can I jump in for a second? I'm Seamus. And reflecting on what Judge Frank had to say about dignity and respect, when families come to our office or any of the offices of the advocates here, it's a hard decision for them to be there in the first place. These are very personal, private issues. Their loved one is being harmed, or they don't believe they're getting access to services, or funding's been cut off. These are major, critical issues to them. And so I try to treat those individuals with respect and dignity. When we meet the individual with a developmental disability or other disability, we do the same thing. One of the most important things that lawyers can do, in my view, is to facilitate dialogue. That includes after a case has been sued, when a lawsuit's been commenced. 95% of these cases settle. They settle on issues that existed in common between the parties before the lawyers got involved. And I'm talking about family law issues, custody issues. 4 or 5% of these cases actually go before a jury. So what's the responsibility of a lawyer and everybody else involved in this dialogue, including, with all due respect, federal judges? It's to facilitate dialogue and reach common ground. Now, I don't want to be the one that has to tell the family that you're not being respected in that process. I think everybody at this panel table and most everybody I know in this audience understands this. But candidly, not everybody in this city, in this country, understand it in the same way. They carry these stereotypes. And one of the most important things that we can do as professionals, as parents, as advocates, is to help bolster that respect and bring that dialogue into the litigation and reach that common ground much earlier in time than some of these cases actually find themselves concluded in. So.
Okay, I'm going to dive into some questions. Can you just, reflecting on your careers, we've heard a couple of examples, but can you give us some examples of specific types of litigation, specific cases where litigation's been used to increase access to services and supports and promote community living and participation for children and adults with disabilities?
Yes, but we can't talk about it today.
I could say that our office in the past brought the big deinstitutionalization case, the Welsh versus Likens case, which ultimately led to the dismantling of the large state hospitals housing people with developmental and intellectual disabilities in Minnesota. Currently, my office has 2 different putative class actions, both in front of Judge Frank, so we really can't talk about them today. One of them we're co-counseling with Seamus and his firm, and another we're co-counseling with another firm, Pro Bono, which is something that, as the questions progress, maybe we'll talk a little bit in an abstract way about how that works. But I think we've had a lot of cases in our office that led to systemic change through, especially in some of the more routine sounding areas, but they're hugely important to people in people who are, for example, may have intellectual and developmental disabilities, but are also hearing impaired and deaf, where we've repeatedly sued various healthcare systems and hospitals in the state for failure to provide interpreter services under a whole range of scenarios. And we have really done a pretty good job of having most of the major systems in the state now agree to, mostly after having been sued, unfortunately, agree to set up systems that will ensure that people who go in for care do get interpreter services. So I think and not all those are class actions. I think especially there's sort of the magic wand theory of the class action, but if one is strategic and with certain issues, one can sue on behalf of an individual or a group of individuals and get class-wide relief, essentially, if there's changes in policies and procedures, in particular with injunctive relief, and in addition to getting possibly damages for individuals. So that's one sort of categorical example that I think you can see there can be success with litigation, even litigation that's not cutting edge, but the results sadly seem to be amazing to some people because it takes so much effort to just push the basic legal rights and have them effectuated.
I mean, just following up on Pamela's, many of the cases we do are on behalf of aggrieved parties, individuals. They'll go on ada.gov and they'll fill out a complaint, and then it'll find its way back to Minnesota if it's from a Minnesota person who's complaining. A couple of examples that come to mind. Up in Harris, Minnesota, on the way north on 35 toward Duluth, one day, fortunately, the family had a paralegal as a relative, and she went on and she said, "We're trying to purchase 3 lots in Harris in a subdivision because my brother is a person with disabilities and he's in a horrible group home right now in North Branch, and we'd like to, my family would like to own and operate a group home on one of the lots, so they're going to build a new home. My parents are going to buy another lot so that they can be nearby in this brand new subdivision. And then the daughter of the disabled person and her husband are going to help run the group home. So there's 3 lots. We signed purchase agreements, but all of a sudden they were canceled because the subdivider had filed a restrictive covenant that said no group homes. Well, totally illegal under state law, and a problem under the Fair Housing Act, federal law. And so we opened up a case. We teamed up with the Attorney General's office. This was a few years ago, and commenced suit in federal court, and we had to immediately move for an injunction because they were in the process of selling all these lots, and they had 3 specific lots they really needed for purposes of running this group home. So fast forward, negotiations, we ended up settling the case. As Seamus mentions, most cases, especially civil cases, settle. And and we had a lot of aggrieved parties because the realtor was fired for facilitating this group home when he should have known better. And so we had to get money to everybody involved, but most importantly, we needed to make sure that those lots were there and preserved. And so ultimately now, if you drive up to Harris, and you would never know this, there's a great group home still run by the family, and this member of the family is one of the adults in this group home. We got involved, the Department of Justice, because there aren't a lot of group homes in what I would consider the very outer reaches of the metro area. where Harris is about 40 minutes from downtown St. Paul. And so the idea was this was a pattern and practice case and a case of general public importance because we want to promote group homes not just in the core cities, but get them out into the community. So as Pamela mentioned, it only really maybe directly impacted one group home, one family, and they really wanted to get that member of the family out of what they considered to be a poorly run group home into one that they were in control of. But we hope, anyway, through publicity and the consent decree, and that it promotes, through education and training, which were part of the settlement, this wider public good, if you will. Just one example.
I know there's other panelists who are going to speak, but before they do that, Greg, could you tell them, our experience has been, I think when we've been on panels before, is a lot of people are maybe thinking, what's this ADA.gov? And maybe you could just explain that, because I think it's really quite incredible if people haven't heard of it.
Well, as far as a government website, it's pretty good. Somewhat user-friendly. We have all our technical assistant manuals on there, including this one from October 31st, which is the new statement from DOJ on the integration mandate under Olmstead, which, interestingly enough, the Star Tribune right away, somebody must have tipped them off, who knows who, and said, this is a message to the state of Minnesota from the Department of Justice that sheltered workshops are no longer favored under the ADA. But the website has a resource aspect to it, and you can download all the publications and the what I call technical assistance manuals and publications. But also it contains every single little teeny tiny settlement agreement that we've entered into, including more broad consent decrees. And then there's the complaint forms under either Title II if you're upset with the government, state, local, or Title III, the private sector. So that it's a pretty easy website to remember, ada.gov.
Thanks. This is kind of playing off of something Pam said, but some cases reach the point of litigation and some don't. What's the role of advocacy around that? How does advocacy influence what ends up being litigated, what doesn't? How are those decisions made?
I can start off. I think Pamela wants to comment on it. In advocacy, what we see is the real life story of people, and combined with our knowledge of what's right, what's legal, what's not legal. And so often the role of advocacy can play a role in then referring an individual client or person to various forms of legal assistance, whether it be the Disability Law Center, a private attorney, the U.S. DOJ. And sometimes we get frustrated because the lawyers will say, well, we can't do that, or the law isn't quite so clear, or, forget truth, justice, and the American way. Because it's so complicated. Not because it doesn't want to do good, but because it's complicated. And so we can identify pockets of practice, pockets of problems, pockets of discrimination, and then connect people to the legal system. And I don't know, Pamela, do you want to jump in on that too?
Sure. Now, I'm sort of representing the point of view of a private nonprofit law firm that's partially funded through different kinds of government funding, including federal funding as the designated protection and advocacy entity. So that means we both have the funding to do this kind of work, but we also have certain prescriptions on how we're supposed to use certain funding. But we're lucky we're not limited about doing things like class actions or representing only citizens, that kind of thing. But that said, that means we do have both limits to what we can do, but also it's great because although we don't get paid very much, we get salaries, so we don't have to take cases just in order to make a living from taking those cases, as long as we're fulfilling our mission. Also, even if people are working class or middle income, because of how our particular funding is as the protection and advocacy entity, we don't have an income means test. So I'm bringing those things up because those are all factors that can weigh into whether certain cases get litigated or not. There are many cases where there's legal rights that are violated, but if there's a person who wants to vindicate their rights, doesn't have the money to pay a lawyer, and there isn't a lot of money going to be gotten from attorney's fees, statutory or otherwise at the end, it can be very hard for people to find someone to even represent them. So that's sort of something to keep in mind when you think about what cases get litigated or not. I would say the second thing is you really do have to have for the most part in our state, you need to have an actual client to litigate something. So through a lot of different avenues, including Roberta might call me about a issue that she's seeing around, or we might get an intake from a client, or we do monitoring visits as part of what we do to go to different facilities, and we see issues there. We participate in a lot of policy groups, for example, at the state and county level, and we're also involved in a lot of national networks of disability rights lawyers. All of these things bring issues to our attention. But in terms of litigation, typically you do need an actual client. In some parts of the country, there's more, in federal court, there's more interest in allowing organizations to be organizational plaintiffs. In the Eighth Circuit, where we are, there's not a lot of appetite for allowing that to happen, particularly with the protection advocacy entities. So generally, we do like to have clients. So that sounds simple, but as we've already heard a little bit, and I think Seamus touched upon as well, it's very difficult for people to become a client in the terms of how much stress it is. Even if they're not paying money to a lawyer, it's a huge time drain. Psychologically, it's very difficult. Many people with disabilities and their families are already very stretched financially, personally, psychologically. It's a very personal thing, as I think, Seamus, you put it very well. You feel exposed when you're in a lawsuit, even if you're being treated respectfully by most of the actors involved. So all of that being said, I think another thing that can limit the ability to bring lawsuits is what you mentioned, Roberta, which is frustrating to a lot of people. Not every really good advocacy issue or problem has a legal theory that will support litigation that is likely to reach the result or change desired in the time frame that people want it to happen. And that can be for a lot of reasons. The law might just be weak. Maybe previous litigation, because of bad court decisions, makes it unlikely that a new case raising the same issues will win. Sometimes if it's a developing area of the law, even within the ADA, for example, a few years ago, it was a big push to say the ADA integration mandate extends to employment. There'd never been a lawsuit. Then Department of Justice and others brought it in Oregon. Now there's some nice law that says that exists. But when you're trying to create a new legal standard, that also is risky, and so it's also generally more time consuming because the courts and the defendants are more likely to resist that. So when you go into expanding the law like that, which is often what advocates and people with disabilities and people like us and the DOJ, and the judge, of course, has no opinion on this, or would really like to see, that can be considerably costly in terms of time of lawyers, experts developing the theories, more than enforcing more settled law. So I think the third thing, and then I'll be quiet and let others chime in, there's always a cost-benefit analysis. You have to weigh the risk of getting a bad decision maybe the facts are distressing, but in a legal sense, the facts are bad. And you're not going to get a good decision because the particular facts for raising a very important issue are not going to lead to a successful result. So it's a cost-benefit analysis in that regard, too. And I think when you're talking with a client, you always have to discuss with them whether there are quicker, more efficient, less stressful ways to get the result they want. And that can be true on really important policy issues that may affect a lot of people where you don't have a good client or a client that would get the result you want. Legislation, rulemaking, administrative complaints, negotiations short of litigation may be backed up by the threat of litigation, complaints to things like the Office of Civil Rights, State Department of Education, licensing. There's just a lot of other avenues short of litigation, and grassroots organizing is another thing. Our office doesn't do that. We're not supposed to do that, but a lot of other people in this room are certainly connected to groups that do.
So I want to just chime in quickly here. First, everything Pamela said is just beautiful and eloquent, so thank you. I want to emphasize, and I don't know how much, Amy, this goes against the theme of this meeting altogether, but before I talked about the limits of staff, employees, policymakers, and how you can try to maybe ameliorate or overcome some of those limits without risking your job. But there are tremendous limits to litigation. And you enumerated a lot of them, Pamela, and I just want to note there's a lot of suffering in the world. There's a lot of suffering among our friends and relatives and people we know and people in our communities, people with disabilities. And the number of lawyers who care about this issue are relatively few, despite so many efforts by Judge Frank and others, and Greg over here. So there are few lawyers, a lot of people who need help, who need suffering, who need representation. And courts can't do everything. Courts can do very little in some major respects. So the little bit of contribution that litigation can make, even though litigation has closed institutions, even though litigation has ended peonage, forced labor of people with disabilities, even though litigation has done many, many things, and even though the ADA has done many things, we have to recognize how limited those possibilities are and how maybe in 50 years we'll see that in the long run that what made the most difference is what Judge Frank talked about, which is really how our culture, how our communities, how all of us treat and care about people with disabilities. I mean, what was most important in Dutch's life was the community, the family that he had. And for all of us to think about how we can increase our relationships with people with disabilities may in the long run do a lot more good than all the litigation that I or anyone else has done.
David, while you have the microphone, can you give us a primer on what a class action lawsuit is and then how decisions are made to move to a class action lawsuit?
Okay, somebody had a question.
Yeah,
should I let's do that?
Sure, take it from.
Okay, is that okay? I don't want to. We won't forget about you. Primer, a true primer. Lawsuits can be filed, of course, by an individual person. We've seen those. We've heard about them. A landlord-tenant case, or somebody suing somebody, who damaged their car or their window. When there are a number of people who are similarly situated, in the phrase in the rule book, people can band together to file a collective lawsuit about issues they have in common with respect to the people or entity that they're suing. So 10 people is probably not enough. 30 to 50 people probably is enough. But there has to be some group of people that have been harmed by some action or policy of some other entity, and they have to have some basis in the law, some right that's been violated, and they want a court to try to help remedy violation of that right. So Pamela alluded to some of this, and it'll fit in with what she said a few moments ago. When I have seen over the years folks who want to file a class action, there's a lot of questions. Can you get what you want quicker if you did it on your own without it being a class action? Somebody came to me recently, had a problem with a technical school to get ready for nursing exam that seemed to be taking their money. Sounded a lot like Trump University. But in any event, this woman who came to me, she really wants her thousands of dollars of tuition back. She said, I want to file a class action. Well, she might get it back quicker if I represented her just in her own case. Class action might take 5-10 years. If she did something on her own, it could be over maybe without a lawsuit. The expenses of lawsuits are much greater, obviously, for a class action than an individual action. And as I think you said, Pamela, you can often make changes in policy and in rules by an individual case that's a test case, so to speak, rather than a class action. So all those decisions have to be made with regard to what you've already heard, which is the impact of the person, of the situation, the legal situation, on the person, and the life that you end up leading if you're involved in a class action. I sued many years ago the Law School Admission Council about discrimination in the law school admission test. 3 named plaintiffs. The lawsuit started, class action, depositions were taken. 1 plaintiff dropped out because she felt the whole process of discovery, deposition, her employers being contacted, the whole legal system, she felt was so oppressive and awful that she just couldn't imagine staying in the case. The next person dropped out because she realized once she filed this lawsuit, she really didn't care anymore about the issue, and so forget it. The third person, the Law School Admission Council gave her what she wanted, gave her the individual relief she wanted for her taking the test. So no more lawsuit, no more representative plaintiff. And the case went away till the Justice Department and some other people recently succeeded. So
Yeah, because I heard
California.
I heard one of those.
you had a question.
Getting back to what Amy's original question was about access, I a little bit want to hear about the definition of disability, which we haven't really talked about. But the World Health Organization looks at disability in terms of functional impairments. But in this country, we generally look at things in terms of diagnoses and categorical issues. And I just wonder your thoughts on, could someone who has great functional impairment without a label, which are mostly made up behavioral observation labels rather than real medical labels, are they as likely to get justice under the law or advocacy as someone with the diagnosis? And I'm particularly thinking for those who interact with insurers, that you can't get access without a diagnosis, even in the light of a great deal of functional impairment. So I'd just like to hear your thoughts about that.
Just some random thoughts. Of course, we're confined by the statutory definitions, either in my life in the Fair Housing Act or in the ADA. And importantly, Congress got upset with the courts, right? And so at the end of 2008, did the ADA Amendments Act to broaden or at least tell the courts how they want the definition of disability to be interpreted in their statute. Now, there's just a couple of things. we don't necessarily have to rely on a medical diagnosis. There's protection under the ADA for a person who's regarded as having a disability but may in fact not have one, right? And that pops up typically in the employment section, but it could be in other contexts as well. Primarily, if it impacts a major life activity that's kind of detailed, you may not need to have the medical diagnosis behind it. So we're not able to kind of jump to like a United Nations definition or some other World Health Organization definition. But I would at least submit that there's some room in the ADA to work with this beyond a specific medical diagnosis. Interesting to hear what the other people on the panel think of that.
I have no doubt that you don't need a medical diagnosis to be covered under the ADA. I also want to note, and you alluded to it, that several federal statutes have slightly different definitions of disability. Fair Housing Act, the ADA, the Individuals with Education, the IDEA for education. But the phrases physical and mental impairment that affect the life functioning, the activities that you refer to. So I know the insurance world is a whole different world, but with regard to the ADA, it's not a question of diagnosis. And I want to point out that the interpretations get sort of strange, but strange for the benefit of people with disabilities. One of the early, maybe the first Supreme Court case dealing with the ADA had to do with a woman who was being discriminated against in employment because she had HIV. No active symptoms, HIV. So is HIV a disability under the ADA? That's what the court had to decide. And they decided in a convoluted way that because HIV could eventually affect her reproductive capacity, that she was covered by the ADA. Her lawsuit was about employment and getting limited in her job or fired, I forget which. So the ADA there, because it affected the major life activity of reproduction, got her in under the ADA. So, and now, of course, we didn't mention Social Security disability, which is a whole other area with other definitions. But don't worry about the medical diagnosis issue if somebody is asserting a right under the ADA.
One thing, though, if I could just say, I wonder what you guys think, though. I agree with what you've both said. I wonder if one of the issues which often would come up would be failure to provide a reasonable accommodation, or what accommodation should there be. Then you would still, in terms of thinking of it from a litigation standpoint, you would likely need to have some kind of a expert to give an opinion that someone with whatever the condition was, even if there wasn't a traditional label from one of the diagnostic manuals, how they thought the person needed X, Y, and Z accommodation because of the condition. So you'd have to have someone on board other than just your lawyer and the person with the disability to back up the idea that they had a functional limitation that needed something that the law was providing. And do you guys think that's... So it's not this. There has to be something, but I think the ADA Restoration Act really was trying to get away from exactly what you're talking about. This sort of, if there's not a label, then it's a great way for courts to toss things out at the get-go, which is what was happening.
One of the things.
Go ahead, Robert. Go ahead.
One of the things I wanted to comment on is often the labels and the various legal definitions are about how do we parse out limited resources. So in Minnesota, to get social services for a mental illness, you have to have a serious and persistent mental illness. Yet we all know that things like a companion animal might prevent someone from becoming seriously and persistently mentally ill. So there's that whole fight about, do we do preventative things that prevent us from getting over into the high-cost programs like Social Security and some of the others? Or do we only fund the deep end of the spectrum? Seamus, you wanted to comment?
There are many paths to justice. When people come into my office, they're not coming in with the sort of prejudged notion that they have an ADA claim or that they have an Olmstead claim. Something is going on in terms of the absence of services or an abuse situation, and they're looking for justice, right? I mean, let's be candid. Who are the best advocates for individuals with disabilities? Parents. To David's point, with the big exception of the individuals at the table to the right of me and a couple in the audience, that has been the experience that I've had as a parent of a child with autism. Parents have to lead this issue because others will not, for various reasons. That's changing here in Minnesota. There's some great things that have been happening through the Disability Justice Program, through the federal courts initiative, through all sorts of different advocates and people like you out there. But the bottom line is families are the ones that have to lead on these issues. And when a family comes into our office, that's what we're talking about. We're talking about a family's issue. They don't necessarily care if it's an ADA violation. Ultimately, lawyers have to figure that out. But there are many paths to justice. Straight up negligence, a breach of contract if it's a group home situation, a constitutional violation, an ADA violation. All of those things need to be considered. You know, I submit that it's not just parents of kids or adults with disabilities that need to lead in that regard. It's others out there. And it's not a decision to simply sue someone. Very often it's me calling Pam or Roberta or somebody else to say, here's a situation involving the absence of services. Or someone just is not understanding this morass of documents written by lawyers that nobody other than a lawyer can understand. It's a crime, folks, and I've been around this for years, and I can't understand these documents. But the people that are doing good work to help provide access to these services are very often the ones that I can connect those individuals with, those families with, and therein lies their justice. Sometimes we have to sue somebody, and as I mentioned before, litigation is another form of dialogue. There are parameters to it, there are rules, there are things like depositions that sometimes you don't like, but that is a path to justice. And I would like to just have everyone reflect on the fact that people with disabilities, in many, many ways, some unknown to the families, are vulnerable. And so a class action lawsuit can speak to individuals who are vulnerable, who for whatever reason don't have a parent that has found their voice, don't have somebody in the family or somebody else, like these good people to the right of me, to speak on their behalf. So a class action lawsuit can do great things. It can bring statewide changes, and it could bring about wonderful things for people with disabilities and their families, and I like that a lot.
Pamela, I think you mentioned that in the decision-making process about whether to litigate a case, whether to take on a case, one of your considerations is sometimes if you took that risk, it might turn out a way you don't want it to turn out. So it might not actually improve access or community living and participation for people. Are there examples that you or other members on the panel have where a case has been litigated and it didn't turn out quite the way you wanted it to and had not so good reputation?
Well, Amy, we get perfect results in all of our cases, so that's a sort of a null set, what you've asked for. But maybe David, with his vast years of experience, can come up with something.
I'll tell you something relevant to a lot of the issues folks talk about today. Some of you may know the term supported decision-making, and there's a lot of thinking in recent years about guardianship and what works, doesn't work, what kind of guardianship, limited guardian, all that kind of that world. Well, many years ago, the state of Pennsylvania had a system of charging people, of course, for their stay in state mental institutions and DD institutions. And the state system was that folks would get their Social Security payments, and the institution appointed the revenue agent, the bill collector for the institution, to be their representative to take the money. So the revenue agent would get the money in one hand on behalf of the person, and then pay the state by handing the money from the right hand to the left hand, with no guardian appointed, no protection, no advocacy, no nothing. So a lawsuit was filed, not by me, about this system. It was declared unconstitutional. And it turned out, I learned 9 months later, the state was collecting the money anyway. They hadn't changed a thing. So I went to court in front of a wonderful judge, Edward R. Becker, who became a Court of Appeals judge. And number one, we got several $1 million back for the patients that had illegally been taken. And we said the state should set up a system. So we sat with the state and eventually with the judge, and we created a beautiful guardianship system. We created a system where everybody, after a certain number of months, would not be allowed, the state would not be allowed to take their money unless a guardian got appointed. How would a guardian get appointed? You had to have a court proceeding to declare the person incompetent, right? So we set up a system, and it turned out to be a beautiful system, pages of regulations. How did it end up working for people with disabilities? Not very well. Number one, the courts set up individual lawyers who know nothing about disabilities to hold hearings at the institution. So in 5-minute hearings over a number of months, hundreds of people were declared incompetent. And today still, if people are a long-term patient in an institution, a guardian is appointed, their rights are taken away, and those regulations now, after 30 years, are still in effect. And that was probably the biggest mistake I've made in litigation, out of my ignorance, or whatever we want to call it, to create a system that ends up being more abusive than helpful, I have to admit.
Mm-hmm.
Do you think, David, though, that at the time that seemed like a good way to solve the immediate problem, and it sort of sounds to me like it's a tale of unintended consequences, and also changing expectations for people's ability to make their own decisions?
Right, and nobody thought about supported decision making at the time, et cetera. And we thought we had protections. Lawyer for the person, you can't file a petition except after a certain number of months, et cetera, et cetera. And I'll tell you a mistake a judge made, if you'll forgive me, Judge Frank.
Oh, you go. I make plenty.
Okay. And this is a sort of premature optimism by a judge, I think I can say. In Texas, we litigated for years a case called Lels, L-E-L-S-E versus Kavanaugh. Hundreds of people were moved to good community programs. Texas, which has 13 state DD institutions, closed 4 of them over several years. The budget went up because a lot of good new services were created. It was terrific. The judge was Barefoot Sanders, was his name, a wonderful judge who ruled in my favor for the plaintiffs in every instance.
That's the definition of a wonderful judge today. But
right. He ruled in my favor, in the plaintiff's favor, on everything except the last order he entered. At the very end of the case, when the state had complied, we asked the judge to retain jurisdiction, to keep watch for a little while to make sure the state did what it promised. These were new orders. We weren't sure what would happen. And Judge Sanders, in a one-page order, said, no, I'll leave the state on its own. And the next legislative session, the legislature took $92 million away from the department that covered developmental disabilities. And the result of that loss and other losses in later years has resulted in the last few years, as you may know, Pamela, in Texas, the protection advocacy agencies now have to go back to court on the same kinds of issues. So the watchfulness that's needed is something that I know that all of you are aware of and that I, as a lawyer, have been very aware of.
One of the, and I know there's a couple other questions there, one of the observations, and I'll be careful because it is kind of a generalization, we'll see what counsel here says, and not unique to disability class actions, but one of the criticisms of class actions generally, and why the U.S. Supreme Court has put some restrictions on the last few decisions they've made. And I'll accept out one thing, that really doesn't apply to meaningful injunctive relief. In other words, separate from how much money the class should get or individual class members. Oftentimes, if there's meaningful changes in injunctive relief, telling people to do something or not to do something, that still can be very, very meaningful in a class action. And then ultimately the test as well, has this really improved the lives of people if it's an injunction or promoted or stopped a practice. One of the criticisms, but it's really restricted to just generally to when there's a class actions damage amount of money, is that, well, the people with really the most damages in the best case get less than what they're really entitled to, and the people with really little or no case for damage, they get more than they're entitled to, and then there's kind of the mean in between. And so sometimes I think the lawyers and judges try to be sensitive to that, but that's very difficult. But I could give you an example without getting into any technicalities. And it's a bit more difficult, I think, frankly speaking, in the disability area. But like I had, federal judges can have what are called all the national, like all cases in America. So right now, and then you're called and asked if you'll take them by Washington. So right now I have all the Stryker hip cases, but about 10 years ago I had all the defibrillator pacemaker cases against Boston Scientific and Guidant. And for America, and just to give you one example, and it's a short explanation, there the lawyers worked hard together with experts and their clients and the court, and we came up with 5 categories. In other words, everybody, so you don't think a class action is one size fits all. We had, like, for example, removal or explant of a pacemaker with complications or removal without complications. And then there's an appeal process that could say, well, here's your range of recovery. And in that case, there was not too much injunctive relief. But sometimes you can have categories, and that's really a test to the fairness as well. Has the action and has the judge approved something that covers all conditions, all categories, because it just isn't, you can have subclasses within the class, and so not to kind of bore you with some of the legalese, but so sometimes that's a true test of the system. Well, did it really improve or did it remedy the issues to address? And then a separate issue, of course, as well, was there meaningful injunctive relief, because I think that is, and oftentimes how the court system is judged. Were there some improvements or changes, or was some practice stopped? Because I think a lot of people say, what exactly is a class action? Is it just one size fits all? And hopefully that's not the case, but there has to be some issues in common and more than just individual remedies. But sorry to get off on some of the more boring aspects of a class action, but I think there was a question or two out there too.
Amy, I have a question. Hi. Two of you now have talked about guardianship in your remarks. The judge talked about it in your opening remarks, and now you've talked about supported decision making. I'm interested. Minnesota, when I was starting in the field, had 7,000 people in the state hospitals, all of whom were on guardianship, because in order to get into the state hospital, they had to have a guardian. I'm wondering what the current community of the legal community is thinking in terms of supported decision making. I heard a very interesting presentation on it in Australia earlier this year, and I'm wondering where we are in Minnesota. What would be the best way to protect the rights of adults to make decisions for themselves, but also to have supports for making those decisions, is guardianship, conservatorship, or supported decision making, or something else, the way we should be thinking about.
I can just say that our office has been actively involved in something, the acronym is WINGS. And of course, I'll make a hash of it if I try and tell you what all those letters stand for. But it's essentially Minnesota now is one of 5, I believe it's still just 5 states in the country who have an actual structure that includes the state court system, a lot of different stakeholders, the private bar who work in this area, our office, many other advocacy groups, and it's not disability specific. It's also would apply to anybody who might need to have some kind of support to make decisions. And the goal of it is it's sort of a acceptance of the idea that some people will need some decision-making support, but it's trying to move away from the idea of formal guardianships, and when some sort of support is needed, trying to come up with new ways to give that support in a less restrictive way. And it's specifically, at least in our way of thinking of it, tied to the idea and the legal requirement now that people should be able to make their own decisions to the extent possible, and to have access to integrated services and living situations. Because too often in Minnesota, as elsewhere, guardians take a more restrictive view of what people are able to do and should be able to strive for than the individual themselves with support would be able to do. And just this past year, the state applied for and got a very large grant to set up a supportive decision-making, I want to call it the Brain Trust, but it's essentially a center, a consulting center, and Roberta might know who's going to be the lead in it. Sure. One of the large nonprofits is going to essentially run that center. So it's really a very significant development, and that's ongoing work. And I'm sure there are other. I know ICI is doing a lot of work in that, which maybe Amy ex officio on the panel could talk about. But
one of the comments I wanted to make, lest you think that some of the comments that were just made are, oh, we would never do that now. We are more and more getting facilities privately run, and sometimes even the state run, that say you have to get a guardian to be admitted here. And it's because they don't want to have to mess with the amount of time or the medications or any number of things. So some old ideas are resurging themselves in today's world. There's very limited beds, options, group home. And so people are kind of saying, if you want to come here, this is what you have to do. And of course, we've been fighting that, but that's a difficult one.
I think that one of the follow-ups I would have to my comment was just there's the rights of the adult with a disability, and then there's also a parent. And Seamus, you talked about this as a parent of somebody with a disability. Sometimes those interests are the same, sometimes they're not. And where does the law stand on that now, and where might it go in near future on that topic?
Wow. Well, let me talk as a parent, because that's what I am ultimately. We're going through it right now. We have an 18-year-old with autism. He just voted. We had to vet very personal, difficult decisions about guardianship. We're waiting on that. I can advocate all day long about these issues, but when it comes to your family and your loved one, it's damn difficult. And I had this conversation in the back of the room before I came up here for the panel with another parent. They're personal decisions. They're not right or wrong. But if I look at Olmstead and what it really, to me as a parent, is all about, it's person-centered planning. The rights, the dreams, the hopes, the aspirations of my son and what he wants. He wants to go to college. He wants to have a family. Right? He wants to vote. All of those things can and should be done in this country, in this state. Autism is a spectrum. There's all sorts of different things happening with that diagnosis. There's all sorts of things happening with people with mental illness and people with cognitive issues. There isn't an easy answer to this, and I'm not sure where the law ultimately comes down, other than as a parent, as an advocate, as a lawyer who tries to help the disposition of justice. We've got to concentrate on the individual first and understand what he or she is all about. And then we have to try to build supports so that we can facilitate their dreams, their goals. Employment, housing, all the things that you and I take for granted, they may not access without proper supports, without proper funding, without appropriate court decisions. There are really good people at the Department of Human Services and within the state that believe in this as well. I happen to think there's a lot of common ground here. I think this issue cries out for a task force that can really deliver some understanding to families, because I'm not sure where it's all going.
One thing that I see in our individual casework, and when I talk to families like Seamus's family, people especially, I think it becomes something people focus on as their kids reach transition age, that a lot of times people that I talk to feel like if they want to have some kind of control or safety for their almost grown up child, they need to get some kind of guardianship. And I've had some interesting conversations with people who've gone to private attorneys who do this. And it depends on if the attorney does a good job talking about what are you trying to accomplish with this legal structure you're thinking about having me draw up papers to impose. And a lot of times, really, what the people I talk to want can't really be accomplished by putting a guardianship, and they end up not doing that because what they realize is right now, if they just take the time to really communicate with their almost adult child and try and bring in outsiders to help. As a parent myself, I'm a big believer in borrowed authority, So even if I say something, if another adult comes in and says it slightly differently and it's not me, then maybe they'll see the wisdom of my secret wishes. But I think guardianship, as you're saying, Seamus, people don't really understand what it is and what it isn't. And the other thing that just seeing so many clients with all different kinds of disabilities throughout my practice, people with disabilities, like the rest of us, change over time, sometimes quite significantly in both their abilities and inabilities. So someone might not need a guardianship. Other types of things to help give them support might work fine for some periods. Maybe they need something more for a while, but nothing should be considered to be permanent. It's sort of a corollary to we don't want to just label people. And one of the really good changes in guardianship law in Minnesota recently is to have more specifics in the guardianship statutes that give people under guardianship the right to return to probate court for any reason to question any decisions of their guardian. And they get a court-appointed lawyer to do that. So I think educating people with disabilities who are under guardianships or conservatorships, that they actually have a lot more control even within that structure for oversight than they actually often know that they do, is really helpful.
Roberta, did you have something you wanted to say? No?
Not in addition to...
Okay.
Well, specifically on guardianship, it's amazing. Minnesota does provide lots of different options: substitute decision making, medical decision maker, who's your power of attorney. And all of those are supposed to be explored before you ever reach the legal status of a guardian. But unfortunately, we deal with perception. So if I walked into the hospital and said, I'm my son's legal guardian, you have to do what I say, 9 times out of 10, they'll just do it. Once in a great while, they'll say, show me your papers.
But Roberta, wait a minute. So I'm not saying, and I don't think you are either, the guardianship is the wrong decision. You're saying there's things you have to go through and look at. You know, a number of the families that we spoke with as we were making this decision did it because they just weren't sure. There was a lot of unknowns. They wanted their loved one to be safe. You know, and I spent a lot of time on it. Representative payee under the Social Security Act, power of attorney, you know, looking at conservatorship on a limited basis. It's daunting, even for someone that, you know, that advocates in this area. Very, very difficult things. But I want to emphasize that deciding ultimately to be a legal guardian is not a wrong decision. But I think there are some things that should be looked at. And I think that's where, call it a task force or a group of professionals who can offer some sage advice online to parents as they're looking at this is really what this should get to.
I think the important thing to remember is, and we've seen it in all ways, normally caring, loving, concerning family, that should really be a personal decision. When we get into family dynamics, family differences, then the assessment sort of changes. And in some cases, when the family is the guardian, it sets them up to be in a power and control struggle that destroys the family relationship. So you have to look at both sides, you know, of this and determine, is professional guardianship better for my loved one? Is family guardianship better for my loved one? And sometimes you need advice.
Seems like there's a question in the audience.
Yeah, going back to the person-centered planning, there's such a push for that right now. And I'm a parent with 2 sons, 16 and 20, both having developmental disabilities, as well as a brother, too, who has a severe disability. And so we're going through the process right now where we're trying to do the person-centered planning with our youngest, who's 16 and is in a group home. And one of the obstacles we're coming against is the county kind of saying, why do you need this? Because he's not verbal. How are you going to have person-centered planning when he can't tell us what he wants? So I'm coming across, I mean, there's a little bit of a wall that I'm coming up to with the county that says you're going to have at least 8 to 10 people at the table in order to do this. You know, we don't have family. We don't have those people. We've taken care of our son all these years. So just, I mean, I guess it's more of just an info to let you know that there are counties right now that, you know, Hennepin County, who's kind of saying, are you I guess I think they're more concerned about my being overbearing and probably wanting things done my way. I'm his mom, you know, I'm his parent, and I, you know, I just to let you know that's out there. There are people who are scrutinizing the person-centered planning because of that. And I guess my concern is, will my voice be as strong as his would be if he could talk? You know, he's nonverbal, severe disability, and I'm concerned that my voice isn't going to be as strong as his would be because I am his voice. My husband and I are his voice. So,
can I comment on that? It just really, too often, bureaucracies worry about a process and not about the end product. So they say a person-centered planning process is you have to have 1 from column A and 2 from column B and 3 from column C. And if you don't do that, it's not a person-centered plan. The second thing is the nonverbal. I have a cousin with a Down syndrome son who's nonverbal. There's no doubt about what he wants. He understands, but he can't articulate. Now, sometimes it's both. They can't understand and they're nonverbal. But people tell us every day, just because they can't tell us in words, you know, if you do something and they wince every time, you think, well, I better stop doing that because it's uncomfortable for him. You are his voice. You know what those little nuances of day-to-day behaviors tell you. You know certain vocalizations are happy ones and certain vocalizations are not happy ones. But it is very difficult because there's no one perfect paradigm that says parents are always right or the individual's always right.
Well, then the counties need to be educated about that.
True.
Well, good for you for being involved as a mom, and I hope that you don't get frustrated to the point of not advocating for your loved ones. I'm assuming there's an IEP involved in the school side. Schools have come a long way to have any number of people at the table to develop an individualized educational plan. The county case manager ought to be invited to go to the IEP planning process, so there's some crossover between the county services and what they know about your loved ones still in school or in the transition program, and what each other is doing. I like a lot what the individualized educational plans are doing into the transition IEPs. Like it a lot more than I did a few years ago. And I think the counties can take notice of that with the local school districts and be trained in order to understand that it's the individual that comes first. It's what they want, what they're all about, and their role is to help bring appropriate supports surrounding the loved one. And so I'm not surprised to hear that the counties are doing that, but it doesn't mean it's right.
Yeah, I agree with what you're saying, Seamus, and I do think the transition age is a challenge for the counties as they're trying to implement this. What we frequently get complaints from families about in your situation, and what they're saying is the county is saying, or from individuals with developmental disabilities themselves, saying the county says they're doing person-centered planning, but they're really not. And when we talk to the county folks, they say, but of course we do. And then when we delve into it, they're having meetings with a lot of people, but then they're presenting the person with the disability and the family with the one choice, and they're having a discussion. They say, well, this was a participatory process, and, well, what do you want, Pam? Well, I'd like X. Well, you can't have X. So we have Y for you. How does that work for you? And that's, I don't mean to sound cynical, but that's really pretty common. So I think the fact that with your son not being verbal, then that compounds the tendency of the counties are trying to comply with the requirement that they do this, but a lot of them really don't have much of a skill set for changing what they've always done. And then if they have a client who's not verbal, that just adds to the challenges. So, I join with Seamus saying, good for you, and I know you won't give up, but and our office, we certainly can try and help if you run into something too.
Hello? Okay. I'm Kelly. I'm another parent, and I just kind of want to piggyback off of what this other parent is. I have a 7.5-year-old son with autism, and I also have a 26-year-old brother with autism who I just got diagnosed this past year, who has fallen between the cracks. So I know different routes parents can do. I do want to talk about the unintended consequences of the MA parental TEFRA fees. Years ago, middle-class families did not have to pay, and families do have to pay, and I've been working really hard testifying against it. For myself, me and my husband, I don't work, I just do parent pay because I have a waiver. But for many families, they don't even want to do the waiver or the CSG, or they want anything to do with it. The only thing that they do is educational. They'll not do anything medical. Before my son was 2 years old, we lived in New Ulm, so I also have the rural versus the Twin Cities view of this. But we did what we could. I asked and I begged, is there anything more? And there was nothing. I moved to the Twin Cities. Then I learned about the TEFRA program because my insurance would not pay for the medical diagnosis at the U and would not pay for the ABA therapies. So we lowered our house, trying to make this payment. I've cashed out my 401k. I've used my grandma's inheritance so I can get my child the medically necessary therapies as possible. I think the unintended consequences, schools, public schools, there's some parents that only send their child to school, and in some cases that might be the right case. But I think as a parent, what's really important is having that medical therapies as well as the educational therapies for the benefit of the child to become the most independent as possible. And I think, person-centered planning as a parent, and now even listening to my son, what he wants, is so important. But with these parental fees, some people, it's not a choice. I mean, they just don't do it. Some people go bankrupt. Some people get divorced. It's just really, really hard. So I don't know what we can do, but I think it's something really important. My son goes to a small Catholic school and has ABA in the classroom, as well as has an IEP with the Roseville School District. And I'm working really hard, but I'm going against the norm with inclusion, and it's really hard. And I know a lot of parents like me are getting tired and worn out, but I will keep fighting for my child.
Good.
Joe, it looks like you have the mic in your hand at least.
Yep, good. I'm a little bit late to the scene here, but what David said resonated with me, and it related to fidelity with the judge letting the state monitor the program, and then the $92 million was taken away the next year. It's on that theme, but it's a much smaller issue, so this may be more of a disability law-related question. But each year I'm involved as an expert witness probably in 9 or 10 cases. Either they get settled, which most of them do. Occasionally an administrative law judge makes a decision. But the issue is fidelity. So everybody agrees that they'll implement something. And in a lot of these cases, within a year or so, I'll see the parent back after the school again because things haven't been implemented that were agreed upon. So the question is, do you find very often in these types of settlements components of the agreement to systematically monitor fidelity? And if you have, then the question is, what are some of the more effective ways that you've seen fidelity monitored so that the two parties can stay out of conflict in the future?
You're talking about individual cases?
My experience is primarily individual, but the question could also go to a larger entity.
Well, and I've done cases involving education of people under the federal education laws, and there is a problem with implementation. I mean, it's just, period. My observation is the same as yours. People end up thinking they've worked something out, and lo and behold, it hasn't been worked out. And with regard to larger issues, I think we heard from the United States a little while ago that the United States, tries to build in attention to accountability, and I think courts often do that too. And there's all kinds of ways to try to look at accountability for the larger or class action type cases.
Yeah, it's tough, right? We tried, as I mentioned earlier, to have continuing jurisdictions so that we can run back to the judge, and we've had to do that. We've had to run back to a magistrate judge in this district to enforce certain provisions. Usually built into all of our agreements is a process so that you don't have to constantly run back to the judge. Some kind of built-in mediation process so that we can nip things before they escalate. It's all kind of contract law, right? And we're trying to enforce an agreement, and parties have have certain ideas about that agreement that you hope you hash out before it's signed, but there's certain expectations that come into play sometimes that can mess things up. The other thing we do is, as things get implemented, we start checking things off. One thing we have not talked about today that I think I'd like to get the other panelists' perspective on is almost every piece of litigation we do, the United States does, has a training component to it. And maybe we've put too much faith in training, but usually if there's a violation of the law, the idea is, all right, you're going to conduct training of all your people within a relatively quick period, and we're going to bless this training and be part of this training so that it's adequate training. And then you're going to have a continuing obligation to train people as they come into your organization or system. I think the federal government's probably put too much faith in training, and we hope then that we never see this defendant or organization again. And of course, guess what? We see them again. And so thoughts about what kind of provisions we put in to both enforce the agreement, but also with the hope that we don't see the organization again by building in some of these provisions. It's the best I think we can do in the litigation context. One little note, I had a case where the city of Minnetonka dismissed a person with a developmental disability who was in high school from their Police Explorer Scout program, right? And he was dismissed, and the police department, as they do, recorded the meeting with the parents and the student when he was kicked out of this program because they couldn't do anything more with him, quote unquote. And there were statements made on the tape that we ultimately got when we wrote the letter to the city saying, you have 30 days to give us everything you have pre-litigation as we investigate this complaint, right? But there were police officers that said, the ADA doesn't apply to us. This is a volunteer organization. The students are volunteers. This Police Explorer Scout program is volunteers. It's not like you're an employee. And so clearly not knowing kind of what the requirements of the ADA were triggered a pretty robust training provision at this city that continues today in their police department, right? That's just one example where we hope then we don't see these folks again, so they know that the ADA just doesn't apply in the employment context, and it employs in all government, public programs, services, and activities. But I'm curious if we've put too much faith in some of these provisions in the litigation context. We have great intentions, but I'm just concerned that maybe there's not enough follow-through, and maybe as to your point, sir, the enforcement mechanism eventually fades, because eventually, Judge Frank, you want to close that case. I've begged to go beyond 5 years in this district, and typically most judges are like, we're only going out 5 years in this consent decree, Mr. Brooker, because
I haven't said that.
because we have to eventually get closure for the parties, and that's a value as well. People need to move on and not be continually dragged into court through enforcement provisions.
Comment I would make on that is it all depends upon what the training is and who does it, and whether there's any fidelity to the training. I mean, people have attended training and been told you have to do it this way, and then they say, but most of us really do it this way. And so the quality of the training makes all the difference in the world. But I think you have to start with a requirement of training, because you don't change systems without exposing people to new information.
Well, if I can step in, for the 95% of the cases that settle, they'll settle either under a consent decree if Greg's involved or a settlement agreement. You can escrow money if there's a money issue, subject to third-party review annually through a certain time until the money is exhausted, with the provision that allows an aggrieved party to seek relief from the court for breach of the settlement agreement. If it's training, you can have a third-party review training on a quarterly basis or an annual basis under the same guidance that if a third party believes that the training has not been adequate or implemented the right way, then the party aggrieved by the absence of the training can go back to court under the settlement agreement for that limited purpose. So that's one way I think to approach it. The other way, of course, is to ask Judge Frank and others to have ongoing jurisdiction, but that's can be problematic because the litigants, the parties that went to court, they ultimately didn't want, unless you're in the United States, I guess, they didn't want ongoing jurisdiction forever. They wanted a resolution on issues in common that allows people to move forward.
My only comment to add is I think that training is useful in a lot of cases. It's not the silver bullet. And sometimes with private defendants, say a hospital system, something as routine as the person who headed the department for the years of the litigation and who thought it was all a great idea gets another job and they forget to transfer the file folder to the new person, and then suddenly we get a complaint that seems identical to the one we just litigated 2 years previously. So that can be kind of frustrating, but that's sort of life, you know. And it does bring up, though, for offices like ours, we're often part of the settlement agreement that and often it's post-litigation, or if we get an order, the other side has to allow us they have to send reports to us about either it's a third party or sometimes it's us because it just works out to get that. And that's also a resource-intensive thing to review the compliance documents, which can go on for years, right? And then, taking enforcement action if you find that they're not in compliance. So, and in terms of the special ed things that you were bringing up, I do think that's a particularly frustrating area for repeated violations. And I think the few lawyers who practice representing students in the state, and there are very, very few, our office is one of a tiny handful that does it, we just accept the fact that we will have many clients who will be our clients from age 3 till 23. Not constantly, but if they have complex issues at each stage, because they keep changing, they may change schools, they change school districts, they just keep coming back because things have to keep changing as they evolve. So I think special ed is a particularly labor-intensive area.
You know, it occurs to me to mention something, since we've heard from a number of parents, especially about what's coming down the road in special ed. The standard for what's an adequate education has been for a long time under an old Supreme Court case, a very low standard. The education has to provide some educational benefit, some courts say some meaningful benefit, but it's not a heck of a lot. And people may have heard that in their IEP meetings, etc. The U.S. Supreme Court will hear this term this year and decide before June what that means and whether or not the standard should be higher than the very low standard the court set many years ago. So folks should know that and sort of watch out for either the standard getting even worse than it is now or the standard improving or changing in some way. Also, the Supreme Court just heard argument, I was there a few weeks ago, in a case involving without going into the whole detail, when a dispute should be covered by the ADA, even if it involves a student in a school, as opposed to the education law, which requires exhaustion of all the IEP process. When can you file a separate ADA case for damages, and when do you have to go through the IEP process, and what's the relationship? And that case will also be decided before the summer.
to follow up on the question that was over here about what can we do for families to mandate that insurers pay for services that are outside the public sector, and what can we do to mandate that people who can't pay for TEFRA get those services?
Well, I think that when you talk about to mandate insurance, the regulatory arms of that are Commerce, Health, and predominantly the legislature. So unless they say it must be a covered benefit in the state of Minnesota, there's not a whole lot. I've argued with many insurance companies that say, well, this person has to go get a new assessment. And I said, they had 5 assessments last week, but you know, now your insurance company doesn't cover those and you want them done again. I said, that's not effective use of healthcare dollars. And same thing with changing providers. Oh, your provider is not in the network anymore. The best you can do is try and have an argument, but they will go fairly prescriptively by what their contract says, which can be governed either under contract from the Department of Human Services, under managed care by the Department of Health, or regular insurance under the Department of Commerce.
I am Kate Onyeneho. What mandate can we have for parents who have PCA workers come to their home to take care of their children with disabilities? And these parents don't have opportunity to work with their children with disabilities. They go to a different house to take care of children with disabilities in order to get money or income. So what mandate can we give to that? Because of their insurance eligibility, PCA, they cannot work with their children with disabilities. This is new to me. I didn't know about that before, but it's happening.
Under some of the programs, a parent or family member may be the person to provide the service. But in other programs, and perhaps under private insurance, I'm not well versed in that. And again, unless there's a mandate to cover it, the various organizations set their own rules. They set their own rules.
CDCS is an option that would allow them to get paid for taking care of their kids. But they're not on a waiver, but I don't know why.
They are not. No, they are not. They are not. No, they are not. They are not. And then what happens is that it is very difficult for them to get that. It's not like call your county social worker, ask the worker to change your insurance eligibility. It is absolutely very difficult for them to do. Mm-hmm. It's not one day. I have a parent that has a child that can't speak, no language at all. Another has autism, but this parent has the opportunity to leave these 2 children to go to a different home to care for another child. Mm-hmm. The person who is caring for these 2 children at once is only 1 PCA, and is 4 hours a day. Another has developmental disability. The parents have no access to take care of their children in the home because of insurance eligibility. They are not on CDCS, but they may be on CDC only in order to have that PCA that has no waiver at all.
You're saying is that they're on medical assistance, but they're not on CDCS. Because if they weren't on MA, they wouldn't be getting PCA services.
Say that again.
Okay, so the individuals with autism or other disabilities must be on Minnesota medical assistance, or they wouldn't be getting PCA assistance. what you need to tell the families is to seriously consider the CDCS program.
I have told them that, but they don't have.
They don't need to be eligible for it. I mean, if they're already on MA, they're eligible. I mean, they have to go through an assessment through the county.
That's right, but the county is not doing it for them.
Well, then I would be referring you to Pamela's office because they should be getting assessed.
You can call my office. You know how to find me.
And the only reason I'm chiming in is that I am a CDCS support planner, so I help families when they get their waivers and help them figure it all out. And I love fighting with the county, so hey, you can call me too. But it sounds like they're not getting properly assessed, and that's their first step to getting towards a waiver. And if they had a waiver, then the parents could get paid to take care of their own kiddos. We are both on a CDCS waiver, and we both are paid to take care of our kids at least part of the time, and then our kids also have nursing coverage. So we are on that program.
I want to back up a little bit. Somebody could just be on MA and not be on TEFRA yet. So they might have to apply for TEFRA and go through the state medical review board team to diagnose their son having a disability. Because several people are on MA, but they don't have a disability. That might be where the...
I'm going to keep us moving along. I know that Cliff had a question that he wanted to ask.
Last week I heard on the news that Congress has not renewed the Civil Rights Bill. That, and one other thing, I heard on the news a person with a disability went to vote. Well, two people at the polling place wouldn't allow them to work. Well, I give credit to the head person at the polling place. He or she said, I'm firing you on the spot, which meant he or she must have good justification because he heard this argument for 5 minutes and said, enough. He has the right to vote with assistance. The other thing, what happens if the Civil Rights Bill, if they do not renew it, is what I'm asking.
So I think, if I'm understanding correctly, it's the Voting Rights Act provision that was struck down by the Supreme Court, that there's a bill before Congress to renew that part of, I think, Section 5. And voting in general is the issue, if I'm understanding correctly. Voting falls under several different federal statutes, but of course, as you know, it's primarily a state and local function, right? Here's what I can tell you. So last Tuesday? It's been such a long time since the election. So we had almost 5,000 DOJ people go out to the country. I know our office, we had some people on the south side of Chicago monitoring voting access. We had some people up at Red Lake, both physical accessibility, but also just accommodations for voting, because lines can be very long, right? And you just cannot sustain that. And so through training and we're back to training again, the training of election officials, it's important that they reach out and accommodate those people, but typically they have to make it known that I cannot wait 2 hours to vote in Miami, right, when the ballots are so long and there's all these other issues on the ballot, and so it's taking forever for people to vote, or whatever reasons why there's long lines, and that's a whole nother issue. So there's both accommodations that are still required under the existing law. So even though Congress maybe hasn't patched this major hole under Section 5 and the pre-clearance stuff, and I'm getting real technical now, there's still generally the ADA, that requires an accommodation. Voting falls under Title II. It is a program, activity, or service of a state or local government. All I can tell you is if there's voting violations, you can go on ada.gov and file the complaint. We do try to, on a regular basis, in between elections, deal with more accessible voting issues, that you need to move this place from this church because it doesn't have an elevator, for example. Or how are you going to accommodate? Is there going to be curbside voting, and is it going to be private? Voting is a very complicated area right now, and we're doing the best job we can with limited resources, but I would submit it's not necessarily a function that Congress hasn't passed that one provision, which is an important provision that needs to be fixed, that the Supreme Court burned down. But there are existing federal laws that protect access to voting, and so I would urge people to, when it's still fresh, just from last week, go on ada.gov and please detail out what happened to you in the voting line or access to voting.
I have an additional suggestion, aside from the ADA. If I understood you right, tell me if I'm right. 2 people with disabilities were prevented from voting in some way? Is that right?
What happened when they got there, their staff was with them? Well, one of the precinct monitors said they couldn't allow the staff to help. Well, after 5 or 10 minutes, the head person at that precinct said, "You're denying them the right to vote. I'm firing you as of now." I think the Secretary of State would have said, "You did the appropriate thing here."
So did the person get to vote?
I think they did. But they fired the 2 people who weren't.
Okay, good. So just so folks know, there's a separate statute called the Help America Vote Act, which guarantees people with disabilities against discrimination in voting and requires the voting systems to be accessible. But Congress has only allowed the Attorney General's office to enforce that provision of the law.
That's right.
Although
so
actually,
individual people can't.
Our office is, though, specifically under that statute. We get a little voting rights money, and so we do a lot of education and some polling place accessibility stuff, which we did with the Secretary of State's office and a bunch of pro bono volunteers that we recruited from corporations and such. But one of the things that our office can do, and it sounds like these folks were able to vote, but we're specifically allowed to help people file those HAVA, Help America Vote Act complaints. And one thing I want to say, we are all quite focused on federal law because we have a distinguished federal jurist here and, the representative of the DOJ and such. But in the voting area, Minnesota is fortunate that we have very strong state law protections that repeat many of the protections, especially for people with disabilities, on things like assisted voting and that kind of thing, in state statute, and also rules that are specific to voting, so state rules that have flesh out the legal standards. So I think especially with things up in the air on the federal level, it's really important to also always think about what our state law protections are here, because Minnesota had a State Human Rights Act before the ADA was passed that is often interpreted pretty much congruent with it to many, with some variations. And I think it's important to look at, we talked a lot about plaintiffs' litigation, but just in my final thought would be we really have to, as disability advocates, focus also on playing really strong defense, because that often is as important as breaking new ground, especially depending on which way the wind is blowing. And the voting case that the judge talked about is a great example. the people bringing that lawsuit were really trying to attack voting rights. And our office became involved in writing an amicus brief to try and, in great detail, protect voting rights. And that was a case that had many, many issues, and the disability issues was one of many. But I think there's going to be a lot of defense opportunities in the next few years, and so I think that's maybe a discussion for another day, but that is something very important to think about as family members and self-advocates as well.
And you're going to get a lot of different results until the whole federal issue gets resolved, because many states don't have the protections that this state law has here. Many states, especially you get down in the South and a few other areas, and it's not there.
Pamela, thank you for a nice transition toward concluding our...
toward ice cream?
Yes. I have direct sight line to the ice cream in the back of the room that I don't want to melt, because rumor has it that is something near and dear to Judge Frank's heart. So I want to take just
That's
a quick...
her euphemistic way of saying I've got an ice cream addiction.
I want to thank our panelists and Judge Frank for spending the afternoon with us, giving you the unique opportunity that you had to hear from their multiple perspectives. So let's thank them.